It's a lot for us to cover with MSNBC legal affairs reporter Fallon Gallagher and former prosecutor and MSNBC legal analyst Charles Coleman. Fallon, first to you, what can we expect from this hearing in the next hour, and who's even there representing ICE?
Yeah, Allie. So Judge Sarah Ellis has called this hearing for this morning to hear from operational leaders in Chicago about 2 incidents involving tear gas that may have violated her order. Now, you'll remember she issued that temporary restraining order, which restricted the use of excessive force. Now, this would have violated that. That order is still in effect, and she even expanded it last Friday to include a mandate that those officers on the ground, those federal agents, must wear body cameras while they're conducting this activity. Now, Russell Hott, who was that field leader there, was originally called to testify. He has since been called back to D.C., to DOJ there. So now there's 2 other agents who will be there. We have Kyle Havrick, who's CBP's deputy incident commander, and Sean Byers, who's ICE's field director there in Chicago. So those 2 are expected to testify in front of Judge Sarah Ellis today. And all of this comes ahead of that November 5th preliminary injunction hearing, which would create a more permanent block.
So, Charles, last week, Judge Ellis said she has serious concerns about immigration agents not following her court order on the use of tear gas and body cameras. So if she's not satisfied that they're following the order, what recourse is there? What enforcement mechanism does she have?
Well, Allie, what you asked is the most important question as part of this entire discussion. We are seeing what happens when an unstoppable force meets an unmovable object. And what I mean by that is the judge has set an order, and it is very likely that the judge is going to expand that order and double down on what has already been stated. But ICE and Homeland Security as a whole has shown a resistance, not only in Chicago, but across the country, in terms of following what the judiciary has instructed them to do about going about their business. And so then the question becomes, what happens next? And I think that it's important for viewers to understand that the judiciary and someone like Judge Ellis in this case has limited recourse around how they respond in this notion, because the normal action would be to find them in contempt. And there are various reasons and various ways that you can actually do that with different repercussions. Ultimately, they would be fines against the office and certain restrictions that would take place. But in a case like this, when you're talking about literally thousands of officers, it's going to be curious as to how each and every documented case of violating that order is proceeded with, and then what the actual recourse is. The judge does have some recourse because they can levy sanctions, and ultimately, if they wanted to, they could move forward in terms of finding them to be in criminal contempt if there is a blatant regard that is found to that order. But that last step is very unlikely to be seen. So it does become a question as to whether Homeland Security and ICE are going to obey what the judge has said.
It would mark a major escalation, though we have seen some judges in other cases have to float that as a potential. You know, Fallon, we're tracking what's happening on that front, but then, of course, we're still tracking the fate of National Guard troops on the ground in Chicago. The Supreme Court has given Illinois and Chicago until this afternoon to respond to President Trump's emergency request to allow the deployment of those National Guard troops to the Chicago area. So then what?
Yeah, that's right. So that's another one of those emergency docket cases that we've been talking about so often. This is coming from another case in Chicago in the Northern District of Illinois, where a different federal judge there, Judge April Perry, blocked the deployment of the National Guard in Chicago. So now the Trump administration late Friday evening went to the Supreme Court and asked them to allow the deployment of the National Guard. Like you said, the Supreme Court set that 5 p.m. deadline for tonight for Illinois and Chicago to respond. Anytime after they get that response, the court could act and submit its order. And so that tells me that they are ready to move very quickly on this, and they could say, President Trump, you can deploy the National Guard, or they can uphold that judge's block and keep that deployment off the table.
It does feel like all there is these days is the emergency docket. But Fallon mentions this, Charles, that an appeals court agreed with Illinois officials that the federal government has failed to show any evidence to justify the use of these troops, despite, of course, Trump's claims that protests in Chicago amounted to what he was calling a rebellion or an invasion. So what is there for the Supreme Court to really consider here?
Ultimately, what are the standards that the president has to satisfy in order to call into the National Guard? It's not the judiciary's place to make that sort of decision because they're not in charge of that. But the Supreme Court may likely be evaluating the validity behind Donald Trump's reasoning for calling in the National Guard, i.e., to protect Homeland Security in the execution of their duties. But I don't necessarily know that the evidence supports that at the level that would require this sort of deployment. So I think the Supreme Court will be balancing what are the requirements for the president to actually execute that level of power from the from the executive branch, and we'll see whether what we have not seen in terms of violence against ICE officers will be sufficient enough to justify the National Guard's presence.
Fallon Gallagher and Charles Coleman, thank you both.